Welcome to the 2016 annual spring meeting of the American Bankruptcy Institute. I am Bill Rochelle, ABI's resident editor-at-large, and sitting with me is my good friend Ed Weisfelner.
Bill, good to see you.
Partner from Rudnick. Ed and I basically grew up in the bankruptcy business together. Known him for decades, more than either of us would like to admit. And Ed, to his great credit, has become one of the very leading lawyers representing bondholders in reorganizations throughout the country. So Ed, welcome to the ABI and thank you for your time.
Thank you, Bill.
This month, the Second Circuit handed down a pivotal decision in the Tribune case involving constructive fraudulent transfers in the context of a leveraged buyout, and it was the creditors who lost again. To my way of thinking, Ed, it looked as though that opinion is essentially saying there is no way on God's earth that creditors are going to be able to get into the pockets of selling shareholders in an LBO. Do you have any feelings one way or the other about that Tribune opinion?
I have one or two feelings about the opinion, yeah. I think, as you know, the Tribune opinion has a lot of ripple effects and some very direct implications for a case that's near and dear to me. I'm the litigation trustee for the Lyondell Creditor Trust as well as the Lyondell Estate Trust.
But you're not in the Tribune litigation.
We're not. We weren't. We weren't up on appeal. We got a favorable ruling from our bankruptcy court, former Judge Gerber, who had ruled on the same issue the Second Circuit ruled on, but he came out in favor of the plaintiffs and my trust. And some people would say that Gerber was sub silentio overruled in Tribune. Not to get too specific, but I think that there are any number of distinguishing fact issues in our case that as, when, and if we need to test the applicability of Tribune to our case, I feel fairly confident that we could convince a court of competent jurisdiction that we have some differences.
Well, now, I believe that there has been a motion for rehearing en banc recently filed in the Tribune case.
Early this week, yeah.
That's right. But assuming that rehearing motion is denied, as they usually are in the Second Circuit, what does that Tribune decision seem to mean?
Well, I think defendants, shareholders who cashed out of busted LBOs, like in Tribune, like in Boston Generating, like in Tina's case, I forget the name of it. It was the one that went up on appeal with Tribune, SEM Group, and Lyondell. The Second Circuit opinion, it will be argued, stands for the proposition that, first of all, 546 of the Bankruptcy Code is not really a safe harbor, it's a safe universe. And that if you were involved or if you received your payment through a financial intermediary as part of a market transaction, and it was a settlement of a securities transaction, then we are told by the Second Circuit that not only can't the trustee in bankruptcy pursue recoveries of those fraudulent conveyances, but likewise there's an implied preemption such that creditors cannot pursue those constructive fraud claims under traditional state law debtor-creditor laws, which never had a safe harbor.
Well, let me ask you this. Assuming there were no bankruptcy, could the creditors in Tribune have mounted a lawsuit for a constructive fraudulent transfer?
Absolutely, with zero limitations.
And you're telling
sounding
me,
in the nature of
you're telling me that because there
harbor.
was bankruptcy, the same creditors cannot bring the same lawsuit?
Let me explain the tortured rationale
Please.
the Second Circuit went through as best as I can understand it, because frankly I disagree with the reasoning. We recognize that fraudulent conveyances are traditionally creditor remedies. They belong to the individual creditors. And in the absence of bankruptcy and before bankruptcy is filed, these are claims that the creditors can bring on their own. under state law. Here's the miracle of bankruptcy and the fiction that arises. Once bankruptcy ensues, you and I, who are creditors and have our own fraudulent conveyance claims, are magically divested of our individual right to bring suit. And instead, our rights and all similarly situated creditors' rights are now vested in the trustee in bankruptcy, which we all know means either the debtor in possession, the trustee in bankruptcy, or any other entity, typically an official committee that obtains derivative standing of the estate's rights. The rationale for taking away your claims and vesting them in a trustee is for convenience sake, to make sure that there's not a mad scramble and the first one to the courthouse wins, and ensuring one of the principal purposes of the bankruptcy code, which is equality of distribution among similarly situated creditors. And Congress, in its infinite wisdom, thought that having the trustee be the focal point for the prosecution of those claims would lead to better, more efficient results. What the Second Circuit is telling us is that once the trustee abandons those claims, or by dint of negotiation gives those claims back to the creditors from whence they came, those claims are transferred back to the creditors, according to the Second Circuit, with the limitation that the trustee had while in bankruptcy. The trustee, the code tells us, can't pursue an avoidance of a constructive fraud if it involved the safe harbor, securities transaction.
So it's like you
settlement.
become infected once you're in bankruptcy,
Right.
and there's no drug to treat
cleansing.
the infection.
So it's, your ability to pursue a claim free and clear of safe harbor, somehow, because there was a bankruptcy and those claims were never prosecuted while in bankruptcy, they're now redelivered to you because the bankruptcy is over. But sorry, Charlie, they got redelivered to you, as you say, with the infection of the safe harbor.
Yeah.
That's what the Second Circuit is telling us.
Well, Second Circuit has been very tough on all aspects of the safe harbor, also in the Madoff case. Well, listen, Ed, I thank you very much for your cut on the Tribune, and we'll have to stick around for 6, 8, 12 weeks and see what the circuit does if they
Indeed.
hold rehearing.
Indeed.
Thank
Pleasure.
you very much for
My
joining
pleasure.
us.
Good seeing you.